Welcome to Sumner School Business Immigration Basics. In this video, we're talking about the prevailing wage determination and the interplay of the prevailing wage determination and showing ability to pay at the I-140 stage, which is the second major stage in the PERM labor certification or employment-based green card process. So what is the prevailing wage determination? As you know, the prevailing wage request is a form that we submit to Department of Labor with basic information about the location of the position, the job title, the suggested SOC code, the job duties, the requirements for the position, and Department of Labor will process that form. Right now, it's taking about 6 to 7 months for them to process. And based on that information, they will determine what the prevailing wage should be. They will then issue the prevailing wage determination, which is actually the same form. They just put their prevailing wage determination on one of the last pages of that same form. They email it back to us. As I said, after they've processed it, which can be right now 6 to 7 months. The prevailing wage amount, I'm just making this up. Let's say that the prevailing wage amount is $75,000 a year. The employer has to agree to pay the PERM beneficiary, so the foreign national for whom you are filing this PERM, the employer has to agree to pay the employee whatever that prevailing wage amount is as of the time that they receive the green card. That's important to note. So it could be that the employer has already hired this person and this person is working in some sort of non-immigrant visa classification, let's say an H-1B or an L or any number of other classifications. So it could be that they're working now and they're earning that amount. So again, let's use the example of $75,000 a year. It could be that they're already earning that amount, $75,000. It could be that they're earning more than that amount, or it could be that the employee is currently earning less than that amount. Any of those scenarios are okay as long as you're meeting the requirements of the non-immigrant visa classification. The employer only has to agree to pay the employee that amount as of the time that they receive the green card, which, depending on the facts of the case, could be years down the road. Could be shorter time than that, but it could be years down the road. In addition, it's important to note that the PERM labor certification process can be for prospective employment. In other words, the employer does not actually have to be currently employing this person. We have lots of clients where the beneficiary of the PERM is working overseas on a contract basis, or for whatever reason does not yet work for that employer, but they will as of the time that they receive the green card. So again, prevailing wage amount has to be paid or higher, has to be paid as of the time that the foreign national beneficiary receives the green card, which could be years in advance or in the future. So what does the prevailing wage determination mean? We know you have to pay that amount, or the employer has to pay that amount when you receive the green card. In addition, that amount, that prevailing wage amount, is critically important because the employer has to show at the I-140 stage, so when we file the I-140 petition after we have the labor certification approved, the employer has to document that they have the ability to pay that prevailing wage or higher as of the date that the labor certification is filed. So let's say, for example, that you file the labor certification on January 1st, January 1st, 2025, just making this up. Then the labor certification application is approved, it's certified as of December 31st, 2025. Again, just making these timelines up. Then the next stage, of course, is filing the I-140 petition. When you file the I-140 petition, you have to show that the company, the employer, when I say you, I'm talking about the employer, the company, the employer has to show that you have the ability to pay that prevailing wage as of the date that the labor certification was filed and going forward. So that would, in this case, be as of January 21st or January 1st, 2025. So how do you show ability to pay? How do you show that you are able to pay this prevailing wage? There are three main ways that you can show ability to pay. There are a couple of exceptions. It is discretionary for USCIS to accept those other potential ways to show ability to pay. So we're really focused when we're doing the analysis of ability to pay, looking at the prevailing wage determination, we're really focused on three things. One is the employee already being paid that amount? If so, then the employer can submit copies of that employee's pay stubs, W-2s, et cetera, to show that they have the ability to pay because they are in fact already paying that amount or potentially more. So that's great if the employee is already earning that amount. Another way that you can show ability to pay is by submitting the company's tax returns, most recent tax returns, or audited financial statements or annual report. It's important to know that those are the three main documents that USCIS will look at. Again, they could potentially accept bank statements or financial statements, but that's secondary evidence, and you really don't want to rely on that unless you have a kind of strategy worked out with your immigration attorney because of unique circumstances. So again, looking at the most recent corporate tax returns, the annual statement, or the audited financial statements. Those are specific terms. Annual statement is typically for companies that are publicly traded, not always, but typically companies that are publicly traded will have those. Sometimes another company that's privately held will still have an annual report. Audited financial statements have to be audited by a CPA. That's a specific accounting term, and it has to be audited financial statements. So looking at the tax returns or the audited financial statements or the annual report, USCIS will look at the company's net income. So that's not the gross income, that's not the top line, it's literally the bottom line of the tax return, the net income. So what is the profit of the company? Or USCIS will look at the net current assets of the company on the tax return. That's typically on Schedule L. Again, that's a specific accounting term. It's not looking at all of the assets minus liabilities. It's looking at the current assets and current liabilities. So typically that's due or receivable within the next 12-month period. So it's specific numbers that USCIS is looking at on specific documents. So in preparing the labor certification before we even file, once we get that prevailing wage determination back, in our office, we do ask employers for copies of their tax returns or other financial documents that I mentioned here, because we want to make sure that you're going to be likely to be able to show ability to pay at the I-140 stage. If we get the prevailing wage determination back and it's a number that the company just can't show, then the I-140 petition will likely be denied and you'll have to start the entire process over again. So again, that's the reason that we're asking for the financial documentation earlier in the process, to make sure that we have the documentation that we need, or likely we'll be able to have the documentation that we need at the I-140 stage. I say likely because, of course, financial statements are issued, or these financial documents, rather, tax returns, audited financials are done every year. So it may be that by the time we file the I-140 petition, there's a new year's tax returns or other financial documents that we'll have to assess, but typically they're more or less in line with what they were the year before. So this is critically important. It's very important to be able to show ability to pay. A couple of other things, as I said, there are potentially other ways to show ability to pay if there is a discrepancy or something really different going on with the company right now. But typically they have a historical, in the past they would have been able to show ability to pay. There's case law that supports that. It is not guaranteed. It is definitely discretionary for USCIS. So really, like I said, we're focusing on these documents. The other thing to be aware of is if you are paying the foreign national more than the prevailing wage right now, that's totally fine. But make sure that if we are your lawyer, that we know that that's something that we look at, or that your immigration attorney knows that, because we do have to take that into account with other aspects of the perm labor certification. You can't offer less to a potential US worker applicant than you would the foreign national. So I hope that you have found this information helpful. If you did, I hope you will share this video with a friend. Make sure you subscribe to this platform so you don't miss our next installment of Sumner School Business Immigration Basics and other videos with current immigration information. My name is Emily Sumner with Sumner Immigration Law, serving clients throughout the United States and from around the world with employment-based and family-based immigration matters. Until next time.